So today's survey question at Smerconish.com asks the following. While well-intentioned, this is an agree or disagree. While well-intentioned, the NFL's Rooney Rule actually encourages sham interviews by requiring at least 2 external minority candidates be considered. Make sure you're going to the website and casting a ballot on that, which I think is a practical question. I want to drill down on some of the legal aspects of this Brian Flores lawsuit, blockbuster lawsuit, and none better to speak about it than NBC legal analyst Danny Cevallos, he from the law firm that he co-founded called Cevallos and Wong. And for the benefit of those who will watch the interview on YouTube, he has dress shamed me today because he has multiple sheepskin behind him, all of his legal licenses and affiliations and educational experiences and so forth. He's wearing a very natty tie and sport coat, and I am in my Yellowstone. I am Kevin Costner today. Danny, are you watching Yellowstone, by the way?
I am not. First of all, hello, how are you? It's great to be here, and I am not watching Yellowstone because, candidly, is just too much stuff to watch on streaming all over the place. And, I've got to watch something my wife wants to watch, so that narrows the class down significantly. So, unfortunately, no, I'm not watching. So I will start in the morning when everyone else is asleep.
So I think Sarah would love it, by the way, knowing just a wee bit about her sensibilities. I always need one show. And it happens to be my one show right now, but I'm about to exhaust season 4, and then I'm done. What are you watching if you're not watching Yellowstone?
Well, I'm pretty mainstream. I like me some Ozark.
Oh yeah,
look, Michael. I'm afraid to tell you the shows I like because, as you know, I am your Sal the stockbroker to Howard Stern. You're my hero, and I don't want to embarrass myself with the shows I watch. But there may or may not be some Boba Fett involved. There's a lot of science fiction. There's a lot of, true crime type documentaries that I don't think anybody else is watching. So, my likes are not in tune with my wife. But when we watch another show, and, producer Dan might shut off my mic right away when I tell you this, but there's a show, 90 Day Fiancé, which we are huge fans of, which would probably make a Michael Smerconish with all his vomit as soon as he watched 5 minutes
my wife is hooked on Below Deck. So much so that for her birthday I made sure I got a cameo from the captain of the boat, and I play the role of drifting through the room and saying, "Oh, what are you watching? Why would you watch that?" And then of course I sit down and I watch it.
Of course. I mean, that's how these shows, I suspect that you're not alone. I suspect that with all of this very, let's say, trashy TV, it's so addictive that even the staunchest opponents can't sit through 5 minutes without getting emotionally invested in these folks' bad decisions. I have to tell you, Michael, as a criminal defense attorney, I think what I love the most about trashy TV is I love the parade of bad decisions. I love people that are out of control because, I'm sure like me, you are 100 times more regimented than I am. And I just love people throwing caution to the wind and making just horrible decisions over and over again. And I can watch from the safety of my home.
With regard to Brian Flores, here was a hypothetical that I floated earlier on the program today. I said, imagine that TC, my colleague and longtime producer, decides she no longer wants to be in Philadelphia. She wants to be at SiriusXM in Washington or in New York City. Everybody in the company knows her. They know she's competent. They like her. She's smart, et cetera, et cetera, et cetera. So whatever the job is that she's applying for, she'd be the odds-on favorite. But if there's a Rooney Rule that applies, doesn't it force a sham process where somebody's going to show up to interview against her, even though kind of the fix is in?
Sure. And I would argue that there's a kind of comparable rule for us trial lawyers. I've been thinking about this, and that rule you may, as I know Michael knows, but folks may have heard of what's called the Batson rule or a Batson challenge. And basically, you can exclude jurors from a jury for virtually any reason using your peremptory challenges, your freebie challenges, with really one exception. You can't do it based on race or some other similar class. And, there's a lot of criticism of the Batson rule. I've been Batsoned myself during trial. And really what it incentivizes is not avoiding discrimination, but instead coming up with facial reasons why you didn't discriminate. And so I think the Rooney Rule incentivizes the same thing. And, using your TC example, it might even harm an eminently qualified candidate like TC because she might subconsciously or consciously be put into the Rooney Rule bucket, or whatever comparable rule there would be, and then not taken seriously. So I think the criticism of the Rooney Rule is fair, and it goes to show that whether it's the Batson Rule or the Rooney Rule, that some of these originally well-intentioned rules, especially to combat discrimination, let's remember that discrimination exists in the mind, and the reason it's so difficult to prove is that people don't ordinarily put in an email, let's keep out all the women, let's keep out all the blacks. So then you have to prove it through either disparate impact in most cases, or you have to prove that somebody had that intent by circumstantial evidence, usually not something blatant. So discrimination is very hard to combat, and sometimes the rules that we create can cause more problems than fixes.
Okay, with regard to evidence then, and as it applies to the Flores suit, tell me, Danny Cevallos, if this is sufficient evidence. Flores' suit says that he was scheduled to interview for his dream job, the head coaching job of the Giants, on January 27, but on the Monday before, he gets confusing texts from New England Patriots coach Bill Belichick. Quote, "Sounds like you have landed. Congrats." That's according to the screenshot that was included in the complaint. Flores responds, "Did you hear something I didn't hear?" And then Belichick, "Giants!" Exclamation point, exclamation point. "You are their guy." Flores, "That's definitely what I want. I hope you're right, coach." And then, as NBC reports, then something seems to have dawned on him. "Coach, are you talking to Brian Flores or Brian Daboll? Just making sure." And Belichick then says, "Sorry, I double-checked and I misread the text. I think they're naming Brian Daboll. I'm sorry about that." Does that make it a slam dunk?
It makes it cringeworthy for Bill Belichick, but no, it does not. And let me give you an example. Let's say that the team decided early on they were going with Brian Daboll, to the exclusion of not just Flores, but everybody else that applied, white, black, irrespective of gender or anything. They may have violated some internal rule, but in terms that would make a discrimination case even harder to prove. The only thing, first, let's say this, those text messages are compelling evidence. I would say almost conclusive evidence, but not necessarily of discrimination based on race. It may be the case that all the other candidates were held in limbo or in a circling pattern, and they were all duped by an early decision. It could be that Brian Daboll was who the Giants coveted for years and years and years, and that from the outset they were going to make the interview process really just a show. Now, does that make it right? No. Could it still be illegal? Potentially. But it is not a smoking gun, at least not when it comes to racial discrimination.
Okay, but Danny, you've taken me full circle. This is the way I was hoping this was going to go, to my TC example, because TC is Brian Daboll, right? Like, she's the insider. She's the one that they want, but now they have to go through this process because of the Rooney Rule.
Right, and by the way, employers probably do this 1,000 times every day. Maybe not based on racial discrimination, but there's always. Look, even in the business we're in, whether it's CNN or NBC or ABC or somewhere else, frequently, you see folks who are line producers move up to, executive producer, and from there on up the chain of command. Internally, promoting from within is seen as a virtue within companies, and yet they typically, large companies, I'm talking about all large companies, not just journalistic or media companies, typically they will post that job and leave it open, and other folks can apply. But, being an insider has been an advantage for getting a job since time immemorial, irrespective of race. Even when all the candidates are white men, being an insider is a boon to anybody applying for a job. Having your foot already in the door is the way to stay in the building. So, yes, this does not rule out discrimination based on race, not at all. But here's the key. Generally speaking, when proving discrimination, the plaintiff has to come forward with facts that to make their prima facie case, their initial case that there is discrimination based on race. But then the burden shifts to the defendant, and the defendant can avoid by showing that maybe there was discrimination, but it was based on all the other infinite discrimination reasons that are perfectly lawful. And that's one thing I think the general public has a misunderstanding about the word discrimination. The discrimination is lawful in 99% of cases. In fact, it's only this small carve out of reasons for discrimination that are unlawful. And even then, if a defendant can make a facial showing, a cosmetic showing that, oh, there's plenty of good reasons why we didn't hire this person. And in fact, that's what the NFL is going to do. I mean, at some point, they're going to argue that Flores was not more qualified than the person they actually selected. And you have to get into that mudslinging of, no, it wasn't discrimination. I expect the NFL might argue that it wasn't discrimination. He just wasn't as good of a candidate. Rooney Rule aside, no Rooney Rule. We chose Daboll because Daboll was better.
In other words, the burden is on Flores to prove it was pigmentation. It was my race that was the reason they wouldn't hire me.
Right, and that's not easy to do. And there are generally two ways to do it. And one is the smoking gun we talked about earlier. The email that says, oh, I like Flores, but he is African-American, and we don't like that. But in modern times, I shouldn't say you never see that because you'd be amazed what you see. You're probably not going to see an email like that. Although I must add, just a few months ago, you saw some really horrific emails emerging from the NFL among coaches and people in high management positions. So who knows what you might find in emails and communications. But absent that disparate treatment, that discriminatory intent, a plaintiff can still show discrimination by disparate impact. And that is obviously not the ideal. The preferred would be that smoking gun email. But if you can show that a number of well-qualified candidates in a protected class were treated disparately, you may be able to make your burden even without that critical email or that text message saying, something disparaging about someone in a protected class, be it race, religion, whatever.
In that issue, is it enough to say that the league is comprised of 70% African-American players and there's only one black coach? Does that get you there? Is that disparate treatment?
I would argue no, not that fact alone, because first, the coaches are a totally different job than the players. I mean, I think one of the reasons folks like sports in America is that they call it a meritocracy. I mean, if you're on an NFL team, there is no regard to race in terms of recruiting players. If you run a 4-flat 40-yard dash, someone's going to look at you no matter what your race is. I mean, that's why I think Americans love sports. It's only the strong survive. It doesn't matter who you know. If your dad's the coach, you're not going to be the starting quarterback in the NFL. Maybe in bantams or peewee leagues, when you're a kid, but not in the NFL. You've got to have the goods to make it. Coaching is a different thing. Coaching's a little more intangible. Sure, you can look at records and nothing else, but I mean, when you hire an offensive coordinator as a head coach, the record means a little less. I mean, a record, a winning or losing record is a significant statistic, but coaching is probably one of those places where discrimination could potentially seep in because it's not a pure meritocracy the way athletics themselves are perceived to be.
Among other things, here's what I'm taking away from Danny Cevallos. I'm taking away that the Bill Belichick texts are a smoking gun for the proposition that Flores was not going to get the gig, but not because of his skin color, right? I mean, that's the bottom line on that issue.
Yes, I can say, safely, well, let me say this. In my opinion, it seems to conclusively prove those text messages that, first, cringeworthy, second, that Flores was never truly in the running. Now, that is, by the way, quite a few steps in the discrimination proving process, but doesn't get you past the finish line, doesn't get you into the end zone. He's going to have to show a little more than that. And by the way, that is why I think strategically this plaintiff filed as a class action, and that's why you see all the allegations about the history of discrimination in the NFL, about things that really don't have anything directly to do with Flores. If, and it's a big if, they can get this class certified. And by the way, if they can avoid the NFL's certain motion to compel arbitration, because they're going to argue this should be an arbitration, then if this case survives, then this class will get massive discovery, far beyond what it would have gotten with Flores as an individual. So if they can survive these obstacles, this case has the potential to be something nuclear, an extant threat to the NFL. Probably not no extant threat since Stuttering John's foot race with Marco Battaglia has posed a greater threat to the well-being of the NFL.
A final point. I've led you in this conversation. Is there anything else about the Flores lawsuit that you think is significant that I've not elicited from you?
Yeah, there were so many damning allegations. Obviously, everybody got hit with shrapnel. I mean,
Right.
They pulled no punches in this complaint. I think one of the most, you talked about the Rooney Rule and whether or not it has a beneficial effect. And I think one of the most compelling statistics, if true in the complaint, is that when the Rooney Rule was instituted, there were 3 black head coaches. Today, after all that work the Rooney Rule is supposed to do, there is 1. So the complaint argues, and I tend to think they have a point, that we've gone backward. And so when you asked earlier, does the Rooney Rule solve the problem? It looks like, at least based on the statistics, the answer is no. And that's a really important lesson, that even rules instituted with the most beneficial, the most noble of aspirations can not only not work, but maybe even have a reverse effect.
Danny, that was all excellent. Danny Cevallos is an NBC legal analyst. Cevallos and Wong is the law firm that he co-founded. Bye for now. I hope you'll come back. That was really great.
Tiki Tai Maine, thank you as always, Michael.
Someday I'm going to bring him on just to have a totally different conversation without
You
any
must.
subterfuge of law.
You absolutely must.